This is Akashwani. In the program Spotlight now, we bring you a discussion on important provisions of Bhartiya Sakshya Adhiniyam 2023. The participants are Ashish Kumar Pandey, Advocate Supreme Court, and Anubha Rohatgi, Anchor.
Bhartiya Sakshya Adhiniyam 2023, which replaces the colonial-era Indian Evidence Act of 1872, will come into effect from July 1st this year. To discuss the important provisions of the Bhartiya Sakshya Adhiniyam, I am now joined by Ashish Kumar Pandey, an advocate practicing in the Supreme Court. Mr. Pandey, welcome to the program.
Thank you for having me.
Mr. Pandey, in December last year, the Parliament enacted the Bhartiya Sakshya Adhiniyam 2023, which replaces the more than 150-year-old Indian Evidence Act, along with two other new criminal laws, the Bhartiya Nagrik Suraksha Sanhita and the Bhartiya Nyaya Sanhita 2023. All these three legislations are aimed at a complete overhaul of the criminal justice system in the country. How significant was the passage of these laws that we inherited from the British?
This is a very pertinent topic we are discussing. You see, there have been allegations. The narrative has been spread in social media that there was no need for these criminal laws, and whatever was going on in the country was serving the purpose. So what was the need to bring all these laws? But you see, as you rightly pointed out, some of these laws are older than more than 150 years old. And now when we are celebrating our Azadi Ka Amrit Mahotsav, even if we don't pay attention to the merits of these changes, the fact is sufficient in itself that we should not follow colonial era laws, which were brought only to serve the interest of colonial rulers. So now you see, one of the very important reasons why these laws have been brought and passed by the Parliament is to make criminal justice system people-centric. And when we say people-centric, it means that focus of these criminal laws is not towards punishment, but towards nyaya. If you see, the concept of justice says that ultimate purpose of any criminal justice system is to ensure that the justice is served. And as far as this particular Evidence Act is concerned, you see, this act was passed in 1872. And what was the point of following this Evidence Act in 2024?
Right. For the benefit of our listeners, can you explain the purpose and role of the Bhartiya Sakshya Adhiniyam? What are the key provisions and what are the new changes in the new legislation vis-a-vis the old act?
As far as the Evidence Act is concerned, first of all, let's come to the point that why this piece of legislation is very important in the entire scheme of criminal justice dispensation system. As you say, there is a popular saying that law is blind. The courts are blind. But when we talk about evidence, this is the filter which the court adopts to see the facts, to look into the facts. And on the basis of those facts which have passed the test of Evidence Act, only those facts are considered for passing any judgment or for adjudication of any dispute. So that's why this piece of legislation is very important as far as the entire scheme of criminal justice dispensation is concerned. Now you see, the reason why new act has been brought, there are two very crucial, there are so many points which we can discuss, but two very crucial points are there which everybody should pay attention to. One is, you see, the nature of crime has changed or evolved over the years. Now we see the criminals are sitting in another country and committing crimes here in India. And earlier, the Evidence Act, there was no provision in that Evidence Act which allowed our courts to take cognizance of crimes committed by someone who's sitting in another country while committing the crime here in India. Now, this Evidence Act indirectly refers to a situation where anyone, if Indian laws are applicable, even if that person is sitting in London or in UK, he can be brought to justice in accordance with Indian laws. And this has to be seen vis-a-vis changes brought in other substantial laws. Like when we talk about Bhartiya Nyaya Adhiniyam. So provisions are there in that code which make Indian laws applicable in other jurisdictions as well. So this is one of the crucial change. And the second change, which is very important, is now electronic evidence has been brought into ambit of Evidence Act. So earlier the situation was that whenever any crime is committed through electronic mode, we see nowadays cyber crimes are on rise, and even the organized crimes, they are using very sophisticated digital and cyber tools to commit crimes. Whenever such crimes were taking place, Indian prosecuting agencies were finding it very difficult to collect evidence and then prove that evidence before the court. Like one of the very recent example is that in Delhi liquor scam, you see, primary evidence which was stored in mobile phones of the accused has been destroyed. Now the prosecuting agencies are struggling to establish what was there in that phone. So such kind of situations have been contemplated and provisions to somehow take care of those things have been brought in new act. So now digital evidence, digital storage of any evidence has been brought into the ambit of definition of documents, which is a primary evidence in the new evidence.
You have just mentioned that an important provision of this new law is the admissibility of electronic or digital records as evidence, which is clearly a nod to the growing role of technology in legal proceedings. Can you elaborate a little more on this aspect?
You see, one of the key reform under this new law is that the statements recorded through digital means, through virtual modes, now has been made admissible under Evidence Act. So any person, even if there may be a situation where accused is deposing before the court, or any witness is deposing before the court, or any other person whose statement is relevant for any proceeding, can depose through electronic modes, through virtual modes. So this provision not only makes this new reality, post-corona reality, accommodated in courtroom proceedings, but from one point of view, it will also ensure the speedier justice delivery system.
You mentioned, of course, that the new act will also help in speeding up the trial process. So that is also my question to you, that introduction of technology and more focus on the use of technology in this new act, will it simplify and speed up the trial? Because in India, we see that the number of cases pending in courts run into lakhs, and that is one of the challenges of the Indian legal system.
You are absolutely right. There are so many cases pending in courts. The reason behind such pendency is obviously one of the reason is our entire process is not that friendly. But other reasons behind the huge pendency is obviously a number of judges vis-a-vis our total population of the country and the judicial infrastructure. But obviously we cannot deny that adoption of technology will somehow help this entire criminal justice dispensation process become speedier. As there is a popular saying in law, that justice delayed is justice denied. So we believe that with the adoption of virtual courts and virtual recording of statements, the entire process will become much speedier, and that will result in speedier justice. And that is one of the key objectives behind passing these legislation.
Evidence, as you pointed out, plays a very crucial role in any court case and its judgment. So, are there any provisions in this legislation to ensure the protection of the witnesses and the innocent?
See, as far as the witness protection scheme is concerned, we have adopted the earlier system. There are not much changes regarding witness protection, but thrust of this new act has been to adopt technology and to ensure that inherent contradictions which were there in the previous act are removed, consolidation of various provisions, and some extraterritorial jurisdiction of Indian laws, which the court can take cognizance of.
What are the challenges in the effective implementation of the new legislation? Because we are talking about increased use of technology, we're talking about the use of forensic sciences. The law enforcement agencies will have to be trained accordingly, isn't it?
Yes, you're absolutely right. In fact, if you see the recommendation of parliamentary committee when this legislation was being deliberated upon was to ensure somehow there is a possibility that during this investigation process, during collection of electronic evidence, there is a slight window of opportunity where the evidence may be tampered with. That window of opportunity which is available to any rogue element in investigating agency has to be closed, and that was one of the key recommendation of parliamentary committee. So, but that has to be seen in future that how during implementation of this law such situation will present itself an opportunity to be adjusted to new realities. So you see, every law is not a final document. It is an evolving piece of document. So maybe in future we will see there will be certain amendments in this act where these particular concerns are addressed.
But would you say that there is, now that there's just 2 months left for the implementation of this law, there is also that urgent need to train the law enforcement agencies? Because when we talk about admissibility of electronic and digital records, to be able to identify those records, to be able to, decipher those records and be able to, present it in a manner that the court will allow it to be admitted, that's a huge challenge.
You're absolutely right. You see, with central prosecuting agencies, we see that be it CBI, Enforcement Directorate, NIA, or even for that matter, Delhi Police, they have very well-trained officers as far as the cyber crimes are concerned. But for the rest of the country, not talking about metropolitan cities, there the situation may be entirely different. So you are absolutely right that there is an urgent need to train our police officers, in fact, to induct certain field experts in police departments. And you see, keeping this thing in mind, in these new laws, there is a provision that certain experts are to be employed. Forensic experts are now required to be part of the investigation process. But that forensic element, will that also include cyber forensic or not? That has to be seen. And as far as the particular area of cyber security and cyber forensic is concerned, there is absolutely, I totally agree with you, that we need to train our police officers.
What steps are needed to make the Bhartiya Sakshya Adhiniyam more effective?
First, you see, there is a very popular saying that even a good law is bad if the implementation of that law is not right, and a bad law is good if the implementation of that law is right. So you see, in the time to come, we will see how our prosecuting agencies will adopt this Evidence Act, Sakshya Adhiniyam, and then during the course of its implementation, only we will get to know that what are practical shortcomings, and then it will be tasked upon the legislature to fill the gaps. That's how any law evolves.
Now, overall, these changes reflect commitment. Be it, we've talked about the Indian criminal laws, the 3 new laws. They reflect a commitment to modernizing criminal laws in India to address the emerging challenges in the digital age. Overall, if you look at it, like you said in the beginning, the focus is going to turn away from the British era laws, which were more towards, punishment. But now the focus is going to be more on delivering justice. How effective will these be in the coming days?
There is a presumption. You see, the intention behind these legislation has been very good. Even just a couple of days back, our Honorable CJI was also commenting that these new laws are going to be revolutionary. So, presumption is that because the thrust of the government is people-centric, the thrust of the government is to make these criminal laws nyaya-oriented rather than punishment-oriented. So, investigating agencies or prosecuting agencies will adopt to new realities, and the courts will also take care of this new approach. The entire system is trying to adopt. You see, one of the very crucial factors which I would like to mention here, you see, first time in the history of India, we have adopted community service as a form of punishment. We had seen many examples where in Western countries, if the crime is not of a very grave nature, then the person accused of that crime is given a punishment that he has to go for community service, let's say for 30 days or 60 days. And that ensures the reintegration of that person with the society, which is one of the primary aim of any criminal justice system. If the person has turned criminal because of maybe certain circumstances, one of the objective is to ensure that not only the retributive justice is given to the person who is victim of that crime, but the person who has committed crime has also been given an opportunity to reconnect with the society. So when these laws talks about community service instead of prison punishment, so this is one of the way the government is trying to address the shortcomings of earlier system. So we are very hopeful, but the fact remains that ultimately laws are just one thing, but at the end, its implementation, which is most important and crucial aspect of entire process.
Mr. Pandey, thank you so much for speaking with us.
Thank you.
You were listening to a discussion on important provisions of Bhartiya Sakshya Adhiniyam 2023. The participants were Ashish Kumar Pandey, Advocate, Supreme Court, and Anuba Rohatgi, Anchor. This program was produced and presented by the News Services Division of Akashvani. You can listen to it on our mobile app News on AIR. This program is also available on our YouTube channel News on AIR Official. You may share your feedback about this program through email at airnsdtalks@gmail.com or WhatsApp on 9289094044.